to acknowledge the presence of the Honorable Attorney General of Ogun State. We had invited him to join this panel because yesterday Ogun State launched its own virtual hearing process. And I think there are a number of experiences that we thought it would be useful for him to share on this forum. But before we get to that point, Mr. Tayo Etibo would like to make 1 or 2 comments on the question of evidence, and then we'll hand over to the last panel and then hear from the AG of Ogun State before we take questions and answers. So Mr. Etibo, over to you, sir. Thank you very much.
Thanks very much, Tunde. Well, my observation will be for the speakers on evidence, and it has to do with subpoenaed witnesses. And I think my Lord, the CJ can also look into this. If you issue subpoena on a witness to testify in a virtual hearing, and he accepts the subpoena, but he refuses to go to the either the office of the counsel at whose instance the subpoena was issued, say a banker, for example, and he decides that he's not going to spend his own data on participating in the virtual hearing. How do we deal with such a situation? Can we look at that? Thanks. Today, I can't hear you today.
I can't hear you.
Sorry, I was, that's a mistake I make all the time. I was still on mute. So I was saying thank you very much for that. And I hope that Professor Shikito and Mrs. Agbo will get a chance to deal with those evidential questions that you raised just now. But now I will move on straight to the next session, which is Mr. Shashorezon and Mrs. Essien, and they are dealing with constitutional questions. We'll then hear the AG of Ogun State, and then we'll come back to Prof. Shikito and Mrs. Agbo to deal with the questions that Mr. Etibo just raised. So, Mr. Shashore, over to you. The floor is yours.
Thank you very much, Tunde. Myself and Mrs. Mia Essien are going to deal with this constitutional problems that can arise, that could arise, and we'll also deal with certain other practical problems around the effective and smooth hearing of these matters within the constitutional context as well. So I will take the first 10 minutes, probably a bit less, and yield to Mrs. Essien, who will take the last leg of the 10 minutes. It's enough to say, several have said it, but I must add my own congratulations to my Lord the Chief Judge for this great innovation of being able to move the reform of the delivery of justice, in this direction. It gladdens our heart in JRP, and I'm sure every stakeholder within the justice sector. But I think one thing to notice immediately is that it's a recognition of a serious paradigm shift that is absolutely necessary in this environment. That is to see the courts as not a physical place, to see the court building as not just the only place where you can get justice, and to see justice as a service that can be delivered to you in a manner of different ways. The fixation on the buildings and the accompaniment of our system has long held back many reforms that are absolutely necessary. So the visualizing of justice as a service and not a place. There's several constitutional problems. I'll outline the 2 major ones. One of them is quickly beginning to slip away, but I'll still mention it nevertheless. We expect, as this practice rolls out, typical of practitioners, and I know my lords and ladies listening will, be very smug about the attitude of lawyers, would raise objections, and many people who are reluctant to proceed with matters such as this will look for ways in which they can avoid it. So it's important that we recognize what the pitfalls are and how they have been dealt with by the courts and how this legal framework can deal with them. People have said to me, and I've seen in commentary elsewhere, that, well, throughout the Constitution, there's no mention of either the word virtual courts, virtual justice, or remote hearings, or et cetera, et cetera. And this has been a valid reason for saying, well, it's not provided in the Constitution, it's not provided by any statute. But I think as far back as 1994 in Agbakuba and SSS, it was well established that the Constitution is an organic document and must always be read within the context of time. And that time will differ from time to time. And so all the issues that have been raised regarding the fact that the words that would now be relied on for virtuality and remoteness do not exist in the context should easily fall away in the light of such decisions. And just to point out, without being too pedantic, that look, the virtuality and remoteness are not always the same. And to also say that we've been involved in remote locations of hearing matters for a while. And I think it was Professor Shikuta before me that mentioned the hearing on a site, the locus in quo, the proceedings conducted in the locus in quo. It's remote from the courtroom. So it's not something that is absolutely alien to our practice to go to a remote location to either take evidence or hear proceedings. But just to tease up these two issues, the two issues broadly factor out into public access to justice and access to justice, to public access to the proceedings and access to justice itself. I'll deal with the latter because it's quickly disappearing, but it was one of the first objections that came out when the approach to this system was evolving. And it's based loosely on section 36(1) of the Constitution, where it says in the determination, and we're all familiar with it, in the determination of civil rights and obligations, the issue of fair hearing by a court or other tribunal constituted to secure independence and impartiality, and the whole concept of the court being a place. I think the comments I've made earlier on would deal with the fact that a court is not a place. It is where the authority of the court is assembled. The majesty of the judex and his judicial powers are properly put into place, and justice is dispensed therefrom. But I think the more problematic one would be section 36(3), which relates to the public access, which I think my Lord, Mr. Justice Oshobi mentioned earlier on, and which clearly occupies the space in the area of possible and rather formidable objection. Formidable, but not indispensable, because I think it's easy to dispense with, and we need to be able to make sure that as a body, we're thinking of ways to deal with these objections. And 36(3) has been pointed out, deals with, and we're familiar with it, proceedings in a court or any tribunal relating to matters mentioned, and the decisions of the court or tribunal shall be held in public. And there goes that word. Now, I think as far back as 1973, in the Oviasu decision, which was cited in the case that my Lord Oshobi relied on, and I'm going to refer to that in more detail. As far back in 1973, in the Oviasu decision, it was clear that judges' chambers is not a regular courtroom, all right? And then this is where the argument has dovetailed on that, well, there is this analogy between a judge's chambers not being a public place or accessible to the public. And then therefore the analogy that if I'm online, it is not a place that is accessible to the public. And therefore it doesn't satisfy section 36, section 36(3), because the word public is not met by an online hearing. And the Supreme Court had held that even if there's no right of ingress and egress as of right, as long as that right can be conferred on the public, the issue of the place can be satisfied, even if it is a judge's chambers. And then that was also treated in Mohammed and Woburn, where the Supreme Court again says, well, acts of secrecy, wherever they are found, will always offend the independence and impartiality perception of the courts. But I don't think the problem came from there alone. In fact, everybody would have been easily forgiven to have thought that Oyeyipo and Oyinoye in 1987, a distinguished panel led by Justice Obaseki, had dealt with the matter entirely. So the analogy of this online hearing being somewhat analogous to decisions of judges or proceedings within the chambers that is being touted today was considered only in the context of hearings in chambers in Oyeyipo. And the court was very clear. And I think it's important that I read part of this. When the court sits in chambers, all it means is that the judges of the court are transacting the business of the court in chambers instead of open court. And it cites an English decision. It does not mean that the court is not sitting in public. A court can sit in open court and yet decide and exclude members of the public other than parties and their legal representatives from the hearing in exercise of its statutory powers. And so it wasn't the fact that you weren't in court, but the fact that you had access to court that would allow a judge's chambers to satisfy the meaning of the Constitution, the wording of the Constitution and the word public. And clearly the argument would suffice for the hearings online, because the argument being touted that, well, I don't have access to the hearing. Now, access is often provided is always provided in a properly constituted virtual hearing, because invitations and links are sent to the public. As my Lord, the Chief Judge said earlier on, not all courts can sit 300 people. And I note in this webinar alone, there are about 500 people listening. So if this was a courtroom and this was court proceedings, you'd have 500 people. So it isn't as of right means that you have access, albeit you are not actually physically there. But then the disturbing matter came with the decision that my Lord Justice Oshobi mentioned, Ikoshebinu and others versus Alimi. So after 1987, that we all thought, well, you know, this issue won't come again. It rose again in 2005, where the Supreme Court agreed with, in 2016, where the Supreme Court agreed with the Court of Appeal in 2005, and essentially said that a court must be, neither the parties nor their counsel, and indeed the public at large, would have access as of right to judges' chambers. So if you place that decision within the context of the objections about public and objections that online proceedings are no longer public, and because Koshebinu and others states that a Supreme Court decision as recently as 2016 seems to be preferred to Oyeyipo, where it was felt that, you know, a court can be in chambers and deliver proceedings and satisfy the Constitution. Now, my answer to the fact that, well, the current state of the law is that the dicta in Koshebinu is one that you must have a hearing in the courtroom to satisfy the word public, is that cannot be the correct position, because Oyeyipo dealt with a range of issues, whereas in this peculiar facts of the Koshebinu decision, the 2016 decision, the court was faced with the fact of a judgment being delivered in chambers. And it wasn't a matter of the proceedings. So one of the ways out of these inevitable objections that will arise will be that hearings, virtual and remote, can be conducted online, but judges should be careful that perhaps in the delivery of the judgment itself, a court is convened in a physical place, even though I don't think Oyeyipo contemplates that case, and it's distinguishable on the peculiar facts. But to arm the judiciary and to arm right-thinking counsel about how to deal with this objection, I think perhaps until something arises, it would be probably prudent to avoid the delivery of judgment in an online proceedings. That could be the way out. But having said that, one must always bear in mind that neither of these decisions, indeed all of these decisions, could not have had practice directions or civil procedure rules as are in the offing under the current situation where the COVID-19 situation has brought about these rather emergency provisions. So the courts could not have been interpreting the state of the law at that time, including rules that didn't exist at the time, and even which would include 2016. And you know, you can be sure that our colleagues would raise these arguments, but the state of the law, as in Koshebinu, deals with only a judgment of the court in that particular case, whereas the dicta in Oyeyipo is a lot more expansive than that and deals with several situations. Before I yield, I think it'll be good for me to point out certain developments abroad that can be of assistance in the thinking behind dealing with this situation. It was brought to my attention by a colleague only just this morning that a decision in April 2020, which is last month, Mr. Justice Aya QC, in a case called Municipal, I can give the citations to the organizers, brought out certain guidelines. And the interesting thing about that is that the guidelines somehow echo the commencement of the protocol that I've seen that the Lagos State Judiciary has released and that we're all considering today. In the early part of the protocol, the practice directions, it states that there are two situations that will be considered. Even though if it doesn't state it in this way that I'm paraphrasing, it says new cases where there is urgency, pending cases involving urgent or important and time-bound interlocutory applications, bail, etc., and any other matter as the chief judge may approve. So it deals with two types of situations where the hearing as of necessity must be conducted because there is an urgency relating to the matter, and a situation where a judge, either delegated from the chief judge or the chief judge himself, says that it is a situation where these proceedings must be held remotely and virtually. And that way you will deal with objections like, as Mrs. Essien will probably treat, cooperation and mandatory cooperation or mandatory participation. Just to run through Justice Aya's guides, and again I'm paraphrasing, he says, one, when the delay results from a response to this prevailing circumstance, the continuation of justice is deemed to be necessary. Two, the disputes can in fact be resolved fairly by a remote hearing. Three, the courts are prepared to hold such a remote hearing. That means the judges themselves have decided that it will be done. Four, under rigorous examination, the possibility of a remote hearing is there. And five, a remote hearing must be treated on a case-specific and dispute-specific basis. So previous speakers on issues of evidence can actually find the proceedings truncated into different parts, where certain parts lend themselves to virtual proceedings and certain parts do not. And in my opinion, as I close, is to say that whatever we do in support of this reform, we must bear in mind that it is designed to ensure that safety is not prejudiced, and at the same time, the risk of injustice is not prejudiced. And if those two factors are satisfied, I think we cannot have a situation where we are all looked upon as a community as being inadequate to deal with, as collectively inadequate to deal with this pandemic and still deliver a system of justice that serves all the stakeholders in Nigeria. And I'll yield to Mrs. Essien on that point.
Thank you very much, Mr. Shashore. I think you ended up on a very interesting note, which is the balance that COVID-19 has forced upon us to try to strike, maintaining health and safety, and on the other hand, ensuring the justice system continues. And that's really what this is all about. Mrs. Essien, I give you the floor.
Thank you. Thank you, Tunde. My Lord, the Chief Judge, my Lord Justice Oshodi, the Honorable AG, the conveners, panelists, my dear panelists, thank you all so much. The lovely thing with speaking at a time like this is by the time it gets to you, everybody has covered the field. So typically, if this were a court of appeal, I could have just said I concur, and then I would still get my honorarium if Tunde was giving us honorarium. But I'll still address some of these issues before my Lord imposes costs on me as he has on Tayo. So why are we having this conversation? COVID-19. In January 2020, if anybody told us we'll be sitting down here looking at our laptops and having a webinar, would have said it's impossible. But that's the reality. Things change so suddenly and we have to adapt to the times we find ourselves. For the same reason, are virtual hearings constitutional? Shukboza addressed everything I would have said, so I won't dwell on that at this point. But just to point out that, as has been said in Rabiu and State, the Constitution is dynamic, and you interpret it as you go. And so I have no doubt that if this were to get to the Supreme Court, the meaning of public would be interpreted in a way that would definitely cover the situation we find ourselves in right now. Because at the end of the day, what are we dealing with? We're dealing with a person's right to fair hearing. And part of that fair hearing suggests that your case must be heard within a reasonable time. For it to be heard within a reasonable time, there has to be access. And if there's anything that's stopping that access, that's where the judiciary comes in. And that's why, my lord, the CJ and other judges, chief judges of other courts have started coming out with their practice directions. Primarily, the focus has been on urgent, essential matters. But then what happens to regular cases? And our analysis tends to focus on the cases that are on the face of those cases urgent and essential. So a bail application is urgent. Fundamental rights is urgent. But that's on the face of it. But I could have a debt recovery case, and the money is important to me, but it's not apparent on the face of it. That is urgent. So I need to be treated in a similar fashion. So how do we do that? And that's part of the conversation we're having right now. So, do the virtual hearings cover the issues of the practical considerations? Yes. And virtually every speaker, my lord, the CJ, Justice Oshodi, I beg your pardon, we've all touched on that. So I won't go into it. But then how do we ensure that it appears so? I think some practical steps. Publishing it on the website, the cause list on a weekly basis, setting out clearly the matters that are stated for virtual hearing so that everybody knows those ones are going to be heard virtually. What are the practical issues we're going to have to deal with? There is definitely going to be a lot of pushback. And if we read the chats, we can see some analysis. For instance, the issue of demeanor of witnesses. But then ultimately, when judges decide cases, they don't decide it based on the demeanor of witnesses. Cases are decided based on the evidence. And so my lords here are familiar with witnesses who will look you in the face and lie through their teeth while looking very, very innocent. So ultimately, I think that there's going to be less focus on how the witness looks, and it's going to be the evidence that supports whatever the witness says. And so in making the justice accessible to everybody, how do we do it? We do know that there are going to be technical challenges, and we've had some already in the course of it. Sometimes it goes off, the connections are not too good. So there's definitely going to be the need to train paralegal support, technical support, both in the judiciary and even amongst practitioners. So we need to have competent support staff. Another point which is essential is that not every case would lend itself to remote hearing or virtual hearing. And I think that point has already been made. Some are more readily disposed to that. Originating summons, fundamental rights, those upon which affidavit evidence, the cases based on affidavit evidence. But family court hearings, matters that are sensitive, things like that, you may need physical hearings. And the reason why it's important for us to remember the distinction is that we're trying to deal with the COVID-19 pandemic situation. So in as much as virtual hearing is appropriate for what we are doing right now, we all pray that, say, in the next 1 year, we'll all be getting ready to go back to court. So we're trying to make provision for the situation we find ourselves in. Will it dovetail into impacting the way we conduct cases on a day-to-day basis? Definitely it will. But I think that when we are having this discussion, I think it's to bear in mind that there will be the possibility of having a physical hearing as well as choosing to have a virtual hearing, depending on the circumstances. And ultimately, it is possible that the chief judges, the heads of court, will make appropriate practice directions or amend the rules so that people may have that choice should they desire. So, but at the same time, talking about pushback for various reasons, even when we started, when we were filing witness depositions, people pushed back written addresses. So it always takes time to introduce new things, and with time, it'll catch on. So what do we then do when a party is uncooperative? The rules would have to take care of that. Now, right now, parties do have to consent. So you'll have to do an analysis as to a case that needs to be heard virtually as against one that is convenient. And so if it needs to be heard virtually, then the state may have to make provision for facilities for those that can't afford the facilities or don't have the facilities. Because whether we like it or not, perhaps you're in Lagos and the internet, you have 5G, you have 6G. Some people in other places may not even have 2G. And that's just going to affect their ability to participate in the remote hearings. And so I think that's the key thing for the court to then decide to make it compulsory in certain instances. And where that is the case, give the parties adequate time for them to set up whatever facilities they need to put up to suit the appropriate purpose. And so using my lords, the chief judges or the chief judge of Lagos State's practice directions, we can see from that one that the parties are actually to agree as to whether they want to have the online hearing, which of course is a good thing, considering the fact that this is new and it's going to take some time for everybody to become acclimatized and used to the procedure. And so the parties right now have to indicate their willingness. In Ogun State as well, there's supposed to be voluntary participation. So I think with that and what everybody else has been said, and with Tunde's timing, I think basically I've come to the end of the practical considerations. And just to say that we all have to move with the times. I did a presentation a couple of weeks back, and I did say then that law practice will be considered in terms of BC and AC, before COVID and after COVID. And I think that's exactly where we are right now. Thank you, Tunde, and I'll
Thank you very much, Mia. Thanks so much. You just underscored what will appear to be a marked difference in the approaches. So Justice Eyre's decision, which Mr. Shashore quoted now, actually starts from the proposition that the person who does not want a virtual hearing has to prove why there shouldn't be a virtual hearing, because the other person also has a right to have his or her case decided expeditiously. In Nigeria, where we seem to be at present is that parties have to consent for there to be a virtual hearing. And that may well be because we have legal provisions that we have to overcome to be able to achieve that through rules reform, through more practice directions. That's a point that I would leave to my Lord, Honorable CJ, to address in his closing comments at the end of this session. I have one other question from him from one of my Lord's learned brothers, which I will also pose. For now, I will hand over to Mr. Bola Adeniro, the Honorable AG of Ogun State, who, like I said, has joined us on invitation because Ogun State ran its virtual hearing process, did a trial run yesterday, and there are some experiences that he will be able to share with us for our benefit. So, Mr. Adeniro, I hand the floor to you. Thank you very much. You're welcome.
Thank you very much, and thanks for the invitation. Again, it's a privilege to participate in this workshop where we can talk about continuing with our justice system. And I think in Ogun State, we understand the issues in two ways. And I think both ways were covered by Mr. Shuposhashore, LawNet Silk, and Mrs. Essie and LawNet Silk as well. And one is basically continuing with justice, a continuation of justice. We need to get our courts back in operation because you can't put justice on hold. And then the second aspect, of course, is trying to see how we can be more effective, more efficient in justice delivery going forward, and how we can deploy technology, whether it's through virtual hearing and so on, to make justice delivery more effective. In Ogun State, when we piloted virtual hearing, I would like to say it was a hearing with an online component or a virtual component. Because the learned chief judge sat in open courtroom, and the defendant, who was in Ibarra prison custodial center, connected via video conference. The counsel, defense counsel, and prosecution were in court, and so the only person who, of course, members of the public also connected remotely, but the only party who was not present in court was the defendant. And so we had to look into ways of getting the connection from the custodial center to the court to be good enough for a virtual hearing. And there are challenges that I take the point that one of the speakers mentioned earlier when it comes to internet connectivity. We were surprised that even in Ogun State, in Abeokuta here at the Ibarra Custodial Center, the quality, the bandwidth of the internet was not good enough for a Zoom video conference. And so when we tested the internet speed, it was 2.6 Mbps. And to have a good uninterrupted video conference, you need at least 5 Mbps. Luckily, we had an alternative that we had worked on, and we did a point-to-point radio connection, which essentially used fiber optics. And so with that connection, we were able to get uninterrupted internet connectivity with Ibarra Custodial Center. But you can imagine that that's because we had the infrastructure in place. There are many places where that infrastructure is just not present. And so when you think about connectivity issues, it's still a thing we need to discuss more broadly. Power was also an issue. At the custodial center, power is not constant. So we had a backup generator, which of course we fueled in preparation for the session. And this is something that people sometimes do not bear in mind, because if you don't have all your emergency backup systems operating, you will have an interrupted session. Troubleshooting support, having technical people on hand who can advise, who can solve problems as they go along. We had a very short period within which to train the court registrars. And so we were able to get the permission of my Lord, the Chief Judge, for one technical person to sit with the court registrars, at least for that session that I held yesterday, so as to hold their hands and guide them through the process. But of course, subsequently, we will organize a training for the judicial staff, as many of them as possible, so that everyone can be on board as to what needs to be done. We would like, of course, the Nigerian Bar Association to also lead from the front. This is an issue that I think affects lawyers. It affects lawyers both working in the public sector and lawyers in the private sector. And unless we have a concerted effort from everyone, the judiciary, it looks as if it's the judiciary that has been leading the effort. Of course, that's not to say that people like Mr. Tunde Fagbonlu and so on have also not been doing a lot. But in terms of the NBA, my opinion right now is that the NBA is not as proactive as I think it should be. I think when we talk about how the proceedings can take place, and I take the point from Mrs. Essie and LawNet Silk, that if we have a balance between virtual and physical, because we are not saying that physical can no longer hold. And I think always having that in mind, that there's always an alternative as long as we respect the NCDC prescription as to how to operate in a safe manner. And so understanding that we can still have physical hearings with online or remote aspects combined with different, so we can have physical, purely physical, we can have purely online, we can have a mixture of the two. And having this as a system to go ahead, a system to pursue, we know that technology in itself is not the solution to everything, but technology can help to assuage some of the problems that we would normally encounter. And of course, this is not to also remove the fact that the attitude of lawyers plays a significant role. And I've been very impressed with today's workshop, because even though we've identified problems, we've looked for solutions to those problems. I've been on many fora, many platforms where we only identify problems and leave it at the problem stage without talking about solutions. And I think we should lead from the front by discussing solutions, because the alternative to all this is that justice just stops. And that's an untenable alternative. And this, for the people who are trying to find solutions to make sure that the wheels of justice continue, I think they should be encouraged, and they should be supported with good ideas, with constructive criticism, so that things can move forward. The experience yesterday, there were the financial aspects to it, because we had to equip the Barra Custodial Center with video conference facility. And of course, this is a federal facility and it's a state government that is equipping them. But we thought that that's something that is important in order not to stall criminal cases, because the defendants also have a right to be heard and they have a right for their matters to continue. And I'm sure everyone is aware of the directive from the federal government preventing any inmate from being taken out of custodial centers to court for fear of catching the coronavirus. And so there are some matters that we have to basically think about, that there's no other alternative but to use virtual components or virtual hearings so that they can continue, and others where it's convenient, it makes things faster, but it's also the possibility that we can also do the same in a physical courtroom. And so that said, I didn't really come in with a prepared speech. I just wanted to share my experience and the experience of Ogun State and in piloting our own virtual hearing yesterday. We intend to expand to all courts in the state, both the High Court and Magistrate Courts. It's a huge exercise. We have to train a lot of people. We have to get a lot of people involved. The Honorable Chief Judge is very much at the forefront. She's leading all efforts in this regard. And she's someone who is proactive. And I think that's very essential if this is ever to go ahead. And I also know that the Honorable Chief Judge of Lagos, with whom I've spoken in the past, is also very passionate about these issues. And so I thank you again for the invitation, and I look forward to the questions.
Thank you, Honorable Attorney General Ogun State. I don't think any prepared speech would have done the job better than what you've done just now. And I think the key for me there, the point you made about justice must continue. And I guess it's up to all of us not to see this as a binary problem. It can either happen or it cannot happen. In between it cannot happen and it can happen, there are so many intermediate solutions that we can all explore to make sure that justice continues to progress. Thank you very much again. If there are any questions for you, I'll bring them to you before the end of this session. We're running very much out of time. I will now go through some of the questions that we have got. I'm afraid I'll probably only be able to take 3 of them because time is running out, like I said. What we plan to do is to curate all these questions that we've got. On the Q&A panel right now at the top right-hand corner of my screen, I can see 44 questions pending. We will not be able to take all of them today, I'm afraid, and with all apologies. but we'll curate all of them into a discussion document, which we will circulate to all participants, and more importantly, to my Lord the Honorable CJ of Lagos State and all other heads of courts, because this workshop has generated quite a number of issues that policymakers must take into consideration, that our heads of court must take into consideration as they begin to prepare perhaps more elaborate practice directions to open up the courts a bit more beyond just what we currently describe as urgent, time-bound, and essential cases. So the first question that's come from one of our participants, I think is relevant to our constitutional panel, and that is Mr. Shukoshashore SAN and Mrs. Mianaya SAN. And the question goes as follows. Can an applicant for bail, for instance, opt for open court hearing, probably for the reason that he does not have confidence in the ability of the correctional center to be able to link up virtually, or because he would not be able to confer with his counsel? That's a question from Dotun Onibokun, Honorable Justice Dotun Onibokun. Our constitutional panel, Mrs. Essien, Mr. Shashore, would you like to deal with that?
Well, I'd be surprised if any person awaiting trial or awaiting the hearing of his bail application is not desperate to get the matter moving forward. So a question of confidence is natural, but the same issues of confidence could always arise even without the virtual hearing. I mean, would he be transported? Would the warders be there? Would there be electricity in the court premises? There are always variables in these sort of things. So, I mean, the short answer to it is that, yes, he could insist on a mixture of both the virtual hearing as well as a physical hearing in order to ensure that his confidence is put to rest. The appearance of a reasonable and fair trial is very important as to the public, as well as it is to the defendant himself. So I think the short answer is yes, he could opt for that.
Yes, and I agree totally with Shukbo, and I don't have anything further to add. Tunde, you're on mute.
Thank you very much, Mia. Thanks for drawing my attention to that again. Very well. The next question I will pose to our evidence panel, and that is, it goes as follows. The Cybercrimes Prohibition and Prevention Act of 2015 provides a list of transactions and declarations that shall not be valid by virtue of electronic signature. That list includes issuance of court orders, notices, official court documents, such as affidavits, pleadings, motions, and related judicial documents and instruments. Does this provision not affect the ability of courts and parties to issue and authenticate documents electronically? Now, my view, I mean, not to preempt the speakers on the evidence panel, but my view, of course, is that this doesn't in any way criticize the process of virtual hearings. It only says, how do you authenticate documents? And my thinking is that if you sign a document in a regular form and scan it and upload it, that does not detract from the fact that it's a valid document, notwithstanding the reference provision of the Cybercrimes Prohibition and Prevention Act of 2015. But I will give the floor to you, Professor Shikwiton, and Mrs. Agbo, for your views on this subject.
Sorry, today, could you add the issue of subpoena witnesses so that I can take it at the same time?
Very, very well indeed. There was a question on subpoena witnesses, and it says as follows: how would subpoenaed documents be attended to? Will there be subpoena hearing at case management conference for submission of documents? Is that the one you had in mind, Mr. Itibo?
No, subpoenaed witnesses. If a subpoenaed witness refuses to cooperate in a virtual hearing, how do you deal with it? He has been served with a subpoena. The normal thing is that he should participate. If he refuses to go to the office of the counsel at whose instance the subpoena was issued, he decides to stay in his office and he says, I don't have data to join your virtual hearing. How do you deal with it?
Very well. So thanks very much for articulating the question, Mr. Etibo. So I'll give the floor to Professor Shikwiton, Mrs. Agbo, and Mr. Etibo, if you wanted to put in any points in addition to what they say, please feel free to do so.
Okay, thanks. Yeah.
Prof.
let me take Mr. Oyetibo's question, which is the last question.
Sure.
In terms of subpoena, when a witness is subpoenaed, it's an order from the court that you must appear at a particular place and time to tender documents or to give evidence. So if for any reason he is not able to attend, the court must know in advance. And if he just sits down in his office and says, I cannot go, I cannot waste my data, then what he does amounts to contempt of court. So I would think that the best thing to do for a witness in the circumstance is to insist that as a witness, the cost of either attending or making sure that the evidence is produced be paid by the party that is asking him to come. It's like you asking the witness to come and testify without tendering the expenses or costs of such a witness. But it will be out of place for anybody who is subpoenaed by the order of the court to refuse to come and say because he has no data. If he has any problem, he should let the court know. Such a witness, I believe, stands a risk of being convicted for contempt of court. Now,
indeed. Yeah. Yes, please.
Yes, now to the other question, which is that the provisions of the Cybercrime Act. We'll have to look at that provision very well and see whether that provision applies to all situations or it applies only to cases that deals with cybercrime. Each legislation has a purpose and it deals with specific issues. It could very well be that when you are looking at whether somebody is going to be convicted for cybercrime or has done ABC and is standing trial under the Cybercrime Act, then that provision will apply. But I doubt if that provision will apply in all situations. Particularly, you take a bill of lading, some are signed electronically. There are banking transactions that are being done on a daily basis electronically. If you say that Cybercrime Act has universal application, that means that all those documents we are signing, all these e-contracts and all documents from countries abroad would also be seen to be violating the Cybercrime Act. I do not think so. And again, to also lend credence to what Tunde is saying, that sometimes when something is signed and a document is signed and is sent electronically, maybe it's you send it by email, scan and send, that does not violate the provision of the Cybercrime Act. At best, what you are doing is you are reproducing a document already reproduced, and it will be admissible as secondary evidence if you lay proper foundation. But like I said, I do not think that that provision is of universal application. I want to believe that we should restrict its application to instances where somebody is being tried under the particular provision of the Cybercrime Act. Thank you.
Thank you very much, Prof. Mrs. Agbo. I don't know if Mrs. Agbo.
I think she went off.
Yes,
no,
yes.
I was trying to unmute. Each time I unmute, I keep picking up the video or something. You all have to get very, very, very adept.
Training, right?
I'm telling you. So I agree absolutely with what Tunde's first initial comments and to what Professor Oshipito has just said. In terms of the subpoena, as I said before, a court, whether it's in-person, physical, virtual, is a court. It is constituted by a judge. So any order that the judge gives is an order of the judge, is an order of the court. So a subpoena is an order of the court asking somebody, requesting or demanding or ordering someone to come and give evidence, whether a testificandum or what's the other one, something.
Yeah.
And a testificandum. All right, so we are still in that age-old time. So obviously, if he fails to comply with the court order, he's liable to contempt. So I think Professor Oshipito has mentioned that, so there's no point repeating that. On the cybercrime issue, I also agree with both what Professor Oshipito and Tunde have said. I think it goes to the admissibility of documents eventually. And we've already had that discussion. It could be once the document has been properly signed and parties agree, maybe at a pre-trial conference of counsel, agree the documents, then those documents go in as evidence. I don't see how, if it's properly authenticated, that parties will not agree that should form part of the bundle of documents that will form part of the evidence that's going to be form part of the bundle of documents that will be used by the courts and by the parties and by the witnesses for the trial. So I don't really see any thoughts there.
Thank you very much, Mrs. Agbo. And then
Today, sorry,
yeah.
can I just keep this in just to support what Prof. Fuke had said? I believe even in virtual hearing, the judgment of the court will still have to be signed by the judge manually before it is circulated. And even the witness statements will still have to be signed manually. So that is not electronic signature anyway. You sign manually, then you can then scan and send. That will not be considered to be electronic signature. So I think the rules will still be met, and the provision that the gentleman has alluded to wouldn't have been violated in any event.
Very well. Thank you very much, my president, Mr. Oyetibo.
Tunde, can I raise the issue?
Yes, please.
There is an issue regarding oath take, which Mrs. Agbo addressed. She addressed the issue of taking the witness who is about to give evidence, taking his oath, but she didn't address the issue of, so with this remote hearings that we want to do, so what happens to affidavit evidence? I think the question was that, so does the witness still have to go physically to the court premises to depose to affidavit evidence before the commissioner for oaths, or is there a method by which this can also be done remotely? I think that was what the question wanted to address. So if she can address it now, it would be very nice. Thank you.
Thank you very much, Attorney General. Yeah.
Yeah. As regards affidavit evidence, that, I guess, that does not really have anything to do with remote hearing or virtual hearing. Is as to a document that will be signed or it is required to be deposed to an oath. I guess that would be part of maybe e-filing. I'm not quite sure, because it will be part of e-filing. So just as you submit a document for into evidence, whether it's primary evidence, whether it's secondary evidence, it's an affidavit, is part of the evidence that you are producing, properly signed and deposed to. So I don't know that you can avoid a physical deposition of the document in the courtroom. I'm not quite sure whether that is possible. I don't know that we can avoid that entirely, except there's an e-process, an e-filing process of that. But the document itself needs to be signed, needs to be properly deposed to. And unless it's agreed that you can have some kind of stamp or seal without it, or you have an automatic seal, if you have an because usually, well, in e-filing of cases in other courts, in other jurisdictions, once you file, it automatically generates a document that shows that it has been sealed. But with an affidavit, I really think it looks as if, to me, from where I sit here, that it may need to be physically signed before a registrar or maybe a notary public.
Yes, I think that maybe the rules should begin to permit litigants to resort to notary publics, so that if the affidavit is notarized before a notary public, it can then be attached to the court processes that will be uploaded. I don't know if my Lord the CJ, I can see maybe he wants to say something on this too.
Yes, of course. Thank you, eminent panelists. like I said earlier, yesterday while we were discussing all these scenarios at our meeting, the issue of swearing to affidavits came up. And what we proposed, which we are likely to set about doing with the appropriate facilities in place, is to have a dedicated commissioner for oaths who sits in a place in our registry here, and the person who wishes to swear transmits the document to the commissioner for oaths here before swearing, and then he takes his oath there, because the relevant words of the law which commands the presence of the person swearing before the commissioner for oaths, before me. So if he can stand there and then take his oath there, which the commissioner at the other end here is listening to and watching, and signs in his presence there, which is also seen, then I think it will satisfy the provisions of the law. There might not be necessity of him coming to court first. He's been able to file E. Now, we have that facility there. It stays somewhere, haven't been allotted his time to come up for the swearing. Now, he swears to the document, he signs in the presence of the commissioner for oath, and in turn, the commissioner for oath also appends his signature at his own end as to attestation. I think the process is completed. That's what we are proposing to do. We are looking into it. But if you can have some other additional suggestions on that modality, you are welcome. So
sorry, my lord.
Yes, please.
Yes, my lord. Would that be
support.
counterpart signing?
No. It will have transmitted the documents electronically to the court. He has filed already. Now he's just taking his oath there. He's signing in the presence of the commissioner for oaths, who is also watching him on the screen. And as soon as he signs, he gets back to the commissioner for oaths here, who also appends his own signature for attestation. And then a certified true copy can always be obtained from this end. That is what we are thinking with.
Yeah. That seems perfect.
I just want to chip in, please. Today, sorry. I just want to chip in on the issue of a witness who is refusing to attend court. I think I support the speakers. It is plain contempt of court. The words of the subpoena, whether duces tecum, as Funke was trying to get, or ad testificandum, or both. The word there is, you are hereby commanded in the name of the governor of Lagos State. Command might seem on democratic language, but then that is what we still have on the summonses. And so it's a command. You cannot use any flimsy excuse. I haven't received the process to say, well, I don't have power, I don't have data, and then you just won't attend the proceedings. No, there's such a person will be liable to contempt. But again, you practitioners are the one who will be at the receiving end. This is because if the man is forced and he now comes over to come and testify, I hope you won't need to declare me a hostile witness. Because so you forced me to come, all right? Tayo, you know what you went through at the tribunal.
I know, my lord.
So we had a discussion.
My lord, CJ, with due respect, there's one application left. The application against Tunde for costs. We're still waiting for the order.
Sorry, so at this point, let me thank you.
In the spirit of this pandemic period, I waive costs.
Thank you very much, my lord. We are going to be logged out in about 30 seconds because we had 3 hours. We actually were thinking we'd finish in 2 hours, but we've done 3 hours. Just a few seconds.
Well, sorry, that's one of the things we also considered here. At our end, when my brother Judge Dada J was reading the judgment, I think we booked for 2 hours. But proactively, we thought, all right, this judgment might go beyond that. So we now increase it to a booking for 3 hours. I think that's one thing we may need to do. And finally, let me just chip in that you lawyers have a lot to do in this enterprise that we are trying to embark on, particularly the senior lawyers and affluent ones like Tunde and all the rest of them. You need to help your juniors to get facilities to be able to latch on to this methodology of hearing. Please, at the bar level. Yesterday, I was speaking here with Dele Oloke when he came shortly after our meeting here. And I told him, look, the branches can buy these laptops for junior ones, ask them to pay installmentally over time so that they will get started from the word go. And once counsel in their substantial number are able to latch on to this, then we have to think of also the citizens. So that if a citizen cannot have a compliant phone or gadget to partake in this kind of a hearing, then the lawyer can call him to his chambers and both of them can be together. At least you'll be able to latch on to the facility of the lawyer and then the proceedings can go on. I think we all have to put all hands on deck in respect of this project. Thank you very much. I thank all of you very much.
Thanks so much, my lord, for those words of conclusion. The Honorable Attorney General, Lagos State, I don't know if you have any final words for this conference before we bring it to a close.
Well, I nothing to add other than to thank everybody for taking out time to make this the success that it has been, and that as we go forward, we definitely need to engage further, learning from all issues that are there, making the process better, making it that it would very much for making our time to be with us today. Both the panelists and all the over 500 participants watching this. Thank you all very much.
Thank you very much, Honorable AG. I want to thank my lord, the Honorable CJ, Lagos State, all my lords, my ladies, your worships who have observed these proceedings, learned senior advocates of Nigeria, ladies and gentlemen of the bar, both from practice as well as in-house counsel who have joined this event. Our friends from abroad, Daniel and Joe, thank you very much for coming to share your experiences with us. We have gathered a lot of useful information in this session. We are going to curate, like I said earlier, we're going to put everything together. We'll build a discussion document out of it, and we'll share it with all the heads of courts and all policymakers who are responsible for ensuring that we have an effective, efficient, and just administration of justice system going forward in these very uncertain times of the COVID-19 pandemic. And indeed, beyond the pandemic, the experiences that we have now, the new techniques and the new knowledge we've gathered will help us even make the justice system better going forward. I want to thank everyone. I now bring this session to a close. I wish you all a very good day and a very good weekend coming up ahead. And please stay safe, everyone. And we'll come back to you with more series and more policy documents. Justice Reform Project, CRID-LawNet, the Ministry of Justice say thank you to everyone. Thank you very much.
Thank you.
Thank you very much.